Ladies and gentlemen, I decided to treat in this keynote speech of this morning a problem that for quite some time was a problem only of theoretical interest without practical relevance, at least in our part of the world. But this has changed, and I think Poland is an example for this change. The problem is the following: how should judges behave if they have reasons to believe that a judgment that they will render is likely to threaten the institution of the court, especially the institution of a constitutional court? I myself have never been in such a situation, but this doesn't mean that it is unknown to Germany. In the beginnings of the Federal Republic, founded in 1945, the court founded in 1951. In the beginning, the early 50s, the newly founded German Constitutional Court was confronted with such a situation. It was immediately involved in issues of high political relevance, the West integration on the one hand, rearmament of Germany on the other hand. 2 or 3 judgments of the court in these very first years incurred the government's displeasure, and there were plans to discipline the court or even to abolish the court. In particular, the Minister of Justice attacked the court in an extremely rude way, and the situation escalated so much that the Constitutional Court threatened to resign completely if the Minister of Justice stayed in office. Adenauer, the first Chancellor of the Federal Republic, didn't want to take that risk, so the Minister of Justice was not reappointed after the next election, but the German Parliament, the Bundestag, passed a law that from now on, justices of the Constitutional Court were to appointed with a simple majority in Parliament. Up to then, it was a 2/3 majority, so simple majority, and you can easily imagine with your experience what that means. It would have been a different court. It would have been a court loyal to the government. The law failed in the second house of Parliament, and this was the first and the last attempt to fundamentally change the Constitutional Court. To the contrary, shortly before Christmas, the Parliament passed an amendment to the German Constitution strengthening the Constitutional Court against possible captures by populist, right-wing, extremist political forces. So what inspired me to take this subject, of course, are the circumstances of our times, but more precisely, it was an article by Ronnie Mann, a professor in Berlin in the Barenboim Side Academy, called Non-Ideal Theory of Constitutional Adjudication. And in this article, she tries to develop criteria for judicial behavior in times of political pressure. And what she has in mind is, of course, a tension or a conflict between how the court would decide an issue according to what the Constitution requires. That's to say, what she calls in ideal situations where the court doesn't have to fear retaliations if it decides against government interests. No danger that the court will be disciplined or dissolved. And on the other hand, what is a wise or a prudent decision in non-ideal circumstances? Non-ideal circumstances for her are the circumstances where the court, if it renders a decision according to what the Constitution required, is in danger of being dissolved or being prevented from functioning orderly. She calls this institutionally hard cases. Roni Mann is, of course, not the first person to deal with this question, but she is not satisfied with the answers to that question that have been given so far. She distinguishes three attitudes in legal literature. The first one she calls ideal constitutional theory. And this means the judges ignore the danger that the court faces. They decide according to the prescriptions of the law, the Constitution. The second theory is called judicial strategy. This is a theory whose adherents are convinced that judges anyway do not care about the law. You know, many of you will know that this is a very common position in the United States, or maybe even more so in the Anglo-Saxon world, not that much in Europe up to now, but judges anyway do not care about the law, but decide cases according to other motives, personal interests, political affiliations, institutional interests, and so on. The so-called legal realism. And then, of course, the problem doesn't arise. They can give any answer that they like, and they will give an answer that reflects their personal interests. The third one is called judicial statesmanship. The judges face the institutional danger and find a solution that is likely to avoid the danger. And after having found that solution, in their reasoning, they make it looking like a legal solution. Roni Mann disagrees with all three of them, and what she misses is a principled answer to that question. She doesn't understand these answers as principled questions. The first approach, because it ignores the consequences of the judgments. The second, because it is a non-legal solution to the problem. The third, because it allows judges to take the threat to the institution into account, to render a prudent judgment, but the theory doesn't provide the judges with principled advice how they should do it. So I think it is rather easy to reject theories number 1 and 2. The first one fulfills Roni Mann's requirement for a principled approach, but it is a suicidal theory, fiat justitia pereat mundus. The second one is neither principled nor normative. It denies the impact of the law, is disinterested in legal reasoning, application of the rational choice theory, so to speak. Now, I would say it cannot be denied that in history and in present times, we find judges and we find courts that do not decide according to legal criteria, but decide in motives of self-interest or ideological commitments, opportunist reasons. That certainly exists, but I would like to insist that this is not the regular case. I would insist that it is a deviation. It's the pathological case. It is not inherent in adjudicating in constitutional or other matters. The difficult case, of course, is the third case. It differs from the first approach in that it allows judges to deviate in extreme situations in order to avoid detrimental consequences for the court. It differs from the second approach in that it believes in the relevance of the law, and that means deviation only in extreme cases. What Roni Mann misses in this third theory is that it doesn't give a principled answer as to which deviations can be legitimized and which deviations are illegitimate. So the question that has to be asked, I think, is what can legitimate a deviation? And this is the question that she asks and would like to answer. To find the answer, Roni Mann for a moment turns to John Rawls, not his famous Theory of Justice of 1971, but a later book called The Law of Peoples, 1999. Law of Peoples is not the same thing like public international law. Rawls is not a lawyer, but is a philosopher. So it is about relations among peoples, but it's not what we understand public international law. And the question that he asks is how well-ordered peoples are peoples under a liberal democratic regime, more or less. How well-ordered peoples should act toward non-well-ordered peoples. In particular, he asks, may they deviate, the well-ordered peoples, may they deviate from the law of the peoples when confronted with activities of non-well-ordered peoples. And Rawls' aim is, of course, that all peoples follow the law of peoples that he describes. However, this is a long-term goal, and it can only be reached in gradual steps. And so Rawls' principle is steps that bring the situation closer to the ideal, justify a deviation from the law, but only a temporary deviation. Rawls also applies that to war. When can we justify war? We can justify war when it brings us ultimately closer to the ideal of what he calls the law of peoples. And Ronnie Mann now applies that to judicial behavior in domestic legal systems. When is it justifiable to render a legally wrong decision? Her central point is that, like Rawls, there is the ideal. The ideal is the application of the law without any side thoughts. So that only such deviations that promise to further the ideal can be justified. The ideal, so to say, is the goal. The deviation is the means to reach the goal under unfavorable, non-ideal conditions. She suggests for judges a two-step approach. First, that the judges should determine what the Constitution requires in a case at hand. And secondly, they should ask which deviations are allowed in this case, more precisely when, under which circumstances, and how. So, brief remark on the when question. She distinguishes two types of situations. The first is an existential threat to a court, to the constitutional court in particular. That's to say, if it renders the decision according to the law, it will be abolished. The deviation is only allowed, in her view, if the threat is imminent and temporary. If the threat is permanent, that's to say, if a system transformation happens, then she would recommend that courts perform what she calls a final act of resistance and then disappear. If there is hope that it is temporary, then courts may take a solution that saves the institution for a moment. Example for hope is, for instance, the hope that in the next election the opposition will win. An experience that you have recently made. Hungary not, for example. So this is one type of non-ideal situation. The other type is not an existential danger, but a backlash to certain constitutional ideals as consequences of the judgment. Say, the ideal is a social state, and the judgment will provoke a backlash with regard to this constitutional ideal. This is a position that she calls the problem of the, problem of the premature decision. The court is allowed to render in this situation a wrong decision, but postpones the right decision to a more favorable moment that one hopes to come. Limited to these two types of cases, Ronnie Mann alleges that she gives a principled answer. Rather than, she says, rather than weighing and cost-benefit and analyzing possible courses of action. As to the second question, how, the answer is the court should not justify a non-ideal judgment in ideal terms. That's to say, the court deviates from the law, but it shouldn't give reasons as if it were derived from the law, but should make it clear that it is a non-ideal judgment, not totally based on the law. And this is because she would like to prevent such a judgment to become later on a precedent for a long line of judgments when the situations have changed. Now, insofar an account of an article which I recommend to read, I think it's extremely interesting, but I add some reflections on this approach. I mean, the dilemma that judges may face has been accurately described. Her approach includes reality into the activity of judging, is certainly a good point of discussion. In general, including reality, you mentioned it briefly in your words when you talked about law in context. In general, including the reality to which the law applies is meanwhile, I think, generally accepted. The aim of all constitutional interpretation is to give utmost effect to the purpose of the constitutional norms under prevailing conditions. What the utmost effect is can only be determined in view of the state of reality to which the law applies. And this means that the segment of social reality must be taken into account. A change of the social reality may make a different interpretation of the law necessary. But this is not what she has in mind. For her, she deals with a specific reality, namely an obstructive reality, a reality that is opposed to or hinders or distorts the realization of the Constitution. This is a different field of thinking. And this hindrance emanates from politics. If the Constitution prohibits what politicians want to do, they are these obstructive reality. You remember, she considers two such threats, the existential one and the partial one, the backlash one. However, between these two threats, I think, there is a possible third threat. This dichotomy is not the only one that exists. Between the threat that affects the existence of the court and the threat that affects the attainment of a social goal, there is a third threat, and this is a threat that you have experienced recently, packing or curbing the court. The court remains in place, but it is remodeled so that decisions against the government are most unlikely. Today, I think this threat is bigger than the threat of a dissolution of a constitutional court. The political forces that pursue a transformation to an illiberal democracy or even an authoritarian system tend to maintain the constitutional court to create the impression that the judicial system goes on functioning, and they draw legitimacy from the existence of the court. Especially in the European Union, of course, where it would be risky to abolish a constitutional court, whereas modifications of some procedural rules or rules for appointment of judges are less prone to provoke a reaction from Brussels. The scenario is familiar to Poland. After the Peace Party gained the absolute majority in 2015, the majority could not immediately pack the court and fill it totally. with loyal judges to the government. So it tried to prevent the court from performing its function properly by changing the procedural rules. After the court was packed, they could repeal some of these rules to, so to say, to give a positive sign to the European Union. You remember all that the constitutionally was challenged. And the question, of course, was according to which legal provisions should the court proceed? The old law or the new law? This question also is not a new question. Before World War I, we had only one constitutional court in the world. That was the Austrian Constitutional Court. And the Austrian Constitutional Court, when Austrian fascism took over in the 1930s, in 1932, the Austrian court was in exactly this situation. After the government had declared that the parliament had dissolved itself, a very doubtful declaration at that time, and after the government had prevented the deputies from assembling in the parliament, they started to rule by decree or by executive order. And likewise, by decree, they amended the law on the Constitutional Court. A law that prevented the justices from ruling in pending cases on such decrees. Now, here too, these new procedural laws in Austria were challenged. And the question for the court was, according to which laws do I examine? The old procedural laws or the new procedural laws? The Austrian court at that time decided it can only rule according to the new laws, and that meant, of course, it abolished itself, so to say. It couldn't rule on matters like this. The Polish court, Constitutional Court, some 80 years later, decided we decide this according to the old rules. And I think, legally speaking, this is the only possible way, because reviewing new procedural rules according to the new, as criteria, the new rules means that we have the identity of the object and the criteria. And this is logically impossible. So the only way is in order to use the old laws. Taking the doctrinally correct approach, the Polish court found the new laws unconstitutional. The government declared the judgment irrelevant, refused to publish it. If I understand it correctly, publishing is a condition of validity of the rule. This seems to be a Polish peculiarity. I haven't found this in other cases in Germany, and most cases I know. The court itself publishes its opinion, so it is in this respect not dependent on compliance of the government. So what the court's decision was, at least, was that the government had to live with the stigma of a violation of the Constitution. The effects of non-ideal situations in the narrow definition that Ronnie Mann gives means that it is permitted in certain cases to decide contra legem. However, that doesn't mean that judges are liberated from all constitutional bonds. Rather, the faithfulness to the Constitution in such a case is redirected from individual constitutional provisions to the Constitution at large. More important than deciding according to individual provisions of the Constitution is to keep the institution that can control rules in place. Commitment to higher goals justifies a deviation from lower parts of the Constitution. By the way, this was the situation in Germany in 1932. In Germany in 1932, communists on the left of parliament and National Socialists on the right together had an absolute majority. And to say they were able to oust any government in the first appearance in parliament. And the problem could only be solved by a constitutional amendment, but the constitutional amendment was the matter for the parliament, so it was impossible to get it. And the considerations at that time were, we postpone against the constitutional rule the existence of this parliament, no new elections, and in the meantime, some constitutional amendments are taken in a non-constitutional way, but in order to save the constitution. And later on, when the situation has changed, they will be ratified by parliament. This idea didn't find the support of the political forces, in particular the Social Democrats. The Social Democrats said the constitution has to be applied and enforced every single provision, whereas the others said a violation of a rather unimportant provision in order to save the constitution at large, and the system is reliable. Carl Schmitt in this situation said, now the doors are open for something totally different. The system has failed to operate, and now the one who has the power goes ahead and dictates what will happen. The tacit assumption behind Rodiman's position is that one can clearly distinguish between a right and a wrong decision. And this is also reflected in her advice to judges, namely this two-step procedure. First, you determine what the right solution to a case is, and the second step, you debate which deviation is possible to avoid this risk. Now, the dichotomy, does it really reflect the conditions under which constitutional interpretation in courts happened? Or is it possible that this rigidity of an either-or misses the reality of judicial decision-making? If so, what is between right and wrong that makes the dilemma less pressing? The question is there only one possible correct decision to a legal issue, or are there probably more than one possible legal solutions? The positivism of the late 19th century and the early 20th century would have insisted there is only one correct answer to a legal issue. If I see it correctly, this is still an opinion prevailing in France, only one correct decision. We don't longer have it. In theory, Dworkin is the representative of the idea any legal issue has only one correct decision. Habermas follows him, but Habermas is not a legal scholar, but a philosopher. The precondition of this idea, there's only one possible correct solution. The precondition is that the text of the law determines its application completely. However, as we all know, norms, and especially constitutional norms, have to cover a vast number of future cases, and the consequence is that they are more or less general and abstract in formulation, whereas the cases that arise under these norms are always individual and concrete. And hence there is a gap between norm and case, and the gap has to be bridged by way of interpretation. And interpretation means to concretize the norm with regard to a case, makes it applicable to the case. That's to say, interpretation is not just the uncovering of a meaning that has been deposited in the text from the enactment on, but to a certain extent, interpretation, concretization is construction of the meaning of a norm. The court has a certain leeway. This must not be confused with a license to decide at will. The end of the textual determinacy of a provision is not the end of the legal argumentation. In the space that the text leaves open, the operation continues to be a legal operation. Doctrine and method and precedents are legal ways of filling this gap. They do not bind the judge in the same authoritative way like the norm, but there are more than, if this is right, there are more than one interpretations possible in the sense of legally acceptable. This doesn't mean to give up the idea of the right decision. The ambiguity of the text does not release the individual judge from reaching subjective, personal certainty about the right interpretation. But the judge has to recognize that another judge who is not less serious than he or she himself arrives at another interpretation, which is then not necessarily a wrong interpretation. This, I think, is important for judicial behavior in non-ideal situations. The existence of an intermediate category between right and wrong shifts back the borderline behind which judges have to take a wrong decision in order to avoid an existential risk to the court. In cases where more than one interpretation is possible, it seems to me justifiable for a judge not to insist on his own impression what is the right decision, but to join another judge's opinion because this interpretation may avoid the conflict. A judge who gives way in such a situation does not situate, in my view, does not situate himself outside the law, but accepts an alternative that is not his, but still is within the legal realm. However, that does not dissolve the dilemma entirely. So if no alternative interpretation is available, so that one has deliberately to take the wrong, would have to deliberately to take the wrong decision. As soon as this situation arrives, one is confronted with the how question. Just as various degrees of right decisions exist, various degrees of wrong decisions exist. The permission to take a wrong decision does not answer the question of how far the deviation from the Constitution may go. Here too, one should expect, following Ronnie Mann's attitude, a principled answer, but she doesn't give a principled answer here. She only gives the advice to make clear that it is not a legal decision, but a legally wrong decision given for other reasons. Possible limits, of course, would be, if that exists in constitutions, absolute constitutional guarantees. German law, of course, human dignity is an absolute guarantee. Cannot be limited, cannot be balanced against other values. So judicial acquiescence with violations of the dignity would have to pay a too high a price for saving the institution. This corresponds with Ronnie Mann's opinion that there may be acts that violate Constitution so grossly that it cannot be tolerated. But what outside this area? In my view, some sort of proportionality considerations or balancing should be applied. The Constitution remains the point of reference for determining the degree of deviation. The deviation is illegitimate if the loss for the Constitution is bigger than the gain for the institution. But Ronnie Mann is averse against proportionality. She hates proportionality and sees proportionality as the opposite of a principal solution. However, in this situation, I think proportionality functions itself as a principle. Usually it is used to solve conflicts between two goods, collision of fundamental rights, but it can be applied as well in conflicts between two evils. Wrong decision on the one hand, abolition of judicial review on the other hand. Ronnie Mann's assumption that there are violations so gross that they are not tolerable is, I think, itself a result of a proportionality proportionality application or balancing without her having noticed it. So it remains one problem, and with this I come to the end. There remains one problem in her approach for which I think she cannot offer a solution. The application of her non-ideal theory requests a judgment by the court as to whether the threat for constitutional adjudication that emanates from politics or the backlash is temporary or is permanent. You remember, if it's temporary, you may be allowed to deviate from the law. If it is permanent, then the court should give a last sign of the rule of law and then disappear. So, depending on the answer to this question, is it temporary or is it permanent, the court either tolerates a violation of the Constitution or annuls the act of government. A principled answer to this question is not available. It's an empirical question. The court must base its decision on a prediction of future development in the real world, not in the legal world. There may be a greater or a smaller likelihood that one or the other will be the case, but errors cannot be included, and I think this dilemma is absolutely unavoidable. Thank you.